Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student of KIT School of Law and currently an intern under LEXCLIQ. In my previous video, I talked about amalgamation, reconstruction and merger. In this video, I will be talking about reverse merger, which is essentially the opposite of merger. Merger or amalgamation essentially involves merger of a loss-making or a less profit-earning company with a good track record to obtain the benefits of economies of scale of production or marketing network or etc. Through the two methods mentioned above, that is amalgamation and reconstruction. The reverse merger is the opposite of merger. No clear definition has been given in the Companies Act about reverse merger, but Indian courts have time and again defined reverse merger. Reverse merger represents a case where the loss-making company or less profit-earning company extends its embracing arms to the profitable company and in turn absorbs it in its fold. The loss-making company in case of such an arrangement is called a shell company. I will be talking about the characteristics of a shell company in the later part of the video. The reverse merger is by no means a new invention. In this era, small to medium-sized privately held companies that were looking to raise additional capital or to make acquisitions were forced to look for methods of going public other than initial public offering. A popular alternative was the reverse merger, which is a transaction wherein a private company merges with it to a public shell company in order to become publicly listed. There are two leading motivations behind these mergers. First, the private company does not want to spend time or money to undergo an IPO, or second, it cannot find an underwriter for its stock but wants to enter into the capital market. However, the Indian courts, though not rejecting the above view, have a different approach. The flow of the Indian court is unambiguously towards the protection of the interest of financial institutions, which in most cases have themselves mooted the idea of reverse merger to the promoter and the protection and welfare of the creditors and members of the loss-making or less profit-making company. From the Indian perspective, it is believed that reverse mergers are predominantly because of two reasons. Firstly, it is a scheme which can be used as a mode of tax savings for a healthy unit. Secondly, to protect the losses of the sick company, as under the Income Tax Act, only the person who has sustained the loss can carry forward the same. In essence, one can say that reverse mergers are rehabilitation oriented schemes and aim at achieving quick corporate turnaround. Now, what are the features of a reverse merger? The Gujarat High Court, in its judgment, Bihari Mills Limited in Re Maneklal Harilal Manufacturing and Co. Limited, laid down the following tests to be satisfied before an arrangement can be termed as a reverse merger. First, if the value of the assets of the healthy company exceeds the value of the loss-making or less profit-making company. The second test is if the net profits after deducting all charges except taxation and excluding extraordinary items attributable to the assets of healthy company exceed those of loss-making company or less profit-making company. Third, if the aggregate value of the consideration being issued by loss-making or less profit-making company exceeds the value of the net assets of healthy company. Fifth, fourth, if the equity capital to be issued by the loss-making or the less profit-making company as consideration for the acquisition exceeds the amount of the equity share capital of loss-making or the less profit-making company prior to the acquisition. Or fifth and the last, if the issue of shares in loss-making company or less profit-making company would result in a change in control of loss-making or less profit-making company through the introduction of a minority or group or minority shareholders. Now, what are the Characteristics of a shell company. A shell company, for the purpose of this project, refers to a loss-making or a less profit-making company. A shell company may be either a former operating company, that is public or private, for some reason has ceased operations and liquidated its assets, or it may be one which never had any operations but was formed from scratch for the specific purpose of creating a shell. In the former situation, shell promoters gain control of defunct operating companies by buying up a majority of their shares. In the later situation, shell promoters incubate the shells, they incorporate a company under Companies Act. In exchange for letting an operating company merge into a shell, the promoter charges the operating company a fee and retains an ownership interest in the shell post merger. Thank you so much for watching the video, and I hope you get some inputs from the video. Please subscribe to the channel, like and share to get further updates. Thank you.